Checkout tracking by the NPD Group brings you a receipt collecting system that gathers data anonymously through technology we created, providing your businesses with answers.
Our next speaker, Stephen Charles McArthur, is one of the finest lawyers in the games industry. To put himself through Columbia Law School, he was a pro gamer back when they called them cyber athletes. He was ranked #1 on both North American ladders for Warcraft 3, and he won the Under-18 World Championship of Magic the Gathering. Ladies and gentlemen, please welcome to the stage, Stephen Charles McArthur.
Thank you. Thank you, Scott. So you all may know Scott as one of this industry's product visionaries, but I know him as simply one of the most genuine people I've ever had the pleasure of spending time with. So thank you, Scott. I'm here to talk about intellectual property with video game companies. And you may not think that intellectual property is very exciting or one of the most interesting parts of your company, but I do. I deal with it every day. I love talking about it. I can talk about it all day, and I think some of you know I will. But we only have about 20 minutes, so I'm just going to go over the 4 most common mistakes that video game companies make with their intellectual property. And before I do that, first, I'm going to go over a very brief overview of why intellectual property should matter to you and why it's important to your company, and then an even briefer overview of what intellectual property is, just to refresh your memories. Okay, so as you can see on this slide, this is a screenshot from the Android store of the game 2048. 2048 was a very popular game last year or the year before, and the person who made 2048 could have trademarked the name 2048 for video games, and he could have turned it into a brand. He could have turned it into a company and a brand worth tens of millions or hundreds of millions of dollars, considering how popular it is. But instead what you have is thousands of clones in the App Store. They're called 2048, there are various versions of 2048, and no one has made any real money off of it. You do not want this to happen to your game. I've seen this happen to many games. Flappy Bird is another example. The owner, frankly, didn't care about protecting his IP, didn't do anything to protect his brand, and what happened is it's now a worthless game. He made a little bit of money off of it, then thousands of clones at the App Store, and he eventually ended up taking his version down, but even if he hadn't, they would have cut significantly into his market share because he didn't take any steps from the beginning. So this is a very basic thing that you just do not want to see happen to your game. For example, if you do not register the trademark for your video game and you were the first person to make Flappy Bird, and then you see a week after you upload it, 10 more people upload their versions of Flappy Bird, and they're called Flappy Bird and they look like Flappy Bird. If you go to Apple, if you go to Steam, if you go to Google, and you ask them to take it down, the first and only question they'll ask you is, okay, what is your registered trademark number? If you don't have a registered trademark number, they will ignore you. Another reason why IP matters to you is it contributes significantly to the value of your company. So when an IP, so for example, when a venture capitalist wants to put money into you, when a large publisher like Tencent is considering buying your company, one of the most important thing they're looking at to purchase, obviously, and investing in is the people of your company. But the second most important thing they're purchasing that they're investing in is your brand and your intellectual property. And if you haven't done everything there is to protect your brand and to build a moat around your IP from day one, your company will be worth millions of dollars less than it otherwise would be. Okay, third reason, intellectual property trolls. Does everyone here or anyone here raise your hand if you've ever heard of a troll in the lawyer sense? Okay, a lot of you. So what these trolls are, it's a pejorative term for companies that make a living suing other companies with no real purpose to take them to trial, and their claims are generally spurious. They're poor intellectual property claims. But their goal is to just get you to settle because you analyze a claim and you say, okay, it will cost me $500,000, $1 million to take this to court and win in court, or $50,000, $100,000 to pay the troll. Rationally, it makes economic sense to pay the troll to go away. But if you protect your intellectual property from the beginning, if you have a trademark for your brand name, for example, for your game title, then you have presumptive right to use your game title. It is much easier to ignore these trolls, to tell them to go away, and in fact, they will actually never come after you in the first place if you've done a very good job protecting your IP. So they won't come after you, and at the end of the day, if you've paid attention to your IP, if you've built it up, you will not burn money on lawyers and in court or just paying off these IP trolls who no one wants to pay off. The last reason. So these slides, this is Angry Birds. And Angry Birds could have easily been another Flappy Bird. There's no reason it couldn't have been another 2048, another Threes. This game is very simple, very easy to clone. Anyone with any experience could make a clone of Flappy Bird, upload it to the iOS store, to Google Play, Amazon, Steam, Facebook games, HTML games online, and make their version of Angry Birds and call it Angry Birds and make all the levels, literally copy the levels bird for bird and unit by unit. But Rovio, and then if that happened, there were just like 2048, there'd be thousands of clones of Flappy Bird on the stores, and you'd never ever heard of Rovio, you wouldn't know who they are. But instead, what Rovio did was they built an empire, honestly, around their brand. And there's not just it's not a video game now. You can buy Angry Birds cereal, you can buy Angry Birds apparel, plushies, all kinds of merchandise. So by building their brand from the ground up, by protecting their intellectual property, they've built an empire, a brand worth hundreds of millions of dollars, maybe billions, around this game, instead of just letting it become the next worthless 2048 Threes or Flappy Bird or any other number of games that have gone that way. Okay. So those are a few reasons why intellectual property needs to matter to every game company and every developer. So what I'm going to do now is just give a very brief overview of intellectual property law, just to refresh your memories. So most people, when they hear intellectual property, they think patents, right? But we're really not going to talk about patents very much today because what's really most important to video game companies are your trademarks and your copyrights. Two often underappreciated aspects of intellectual property, which are actually much more important to you as a video game company. So here, for this example, we have Final Fantasy. So Final Fantasy, that's a game title. And as a game title, that title is trademarked. This is Final Fantasy Brave Exvius. This is their mobile title coming up later this year. So trademarks include your product name, your video game name. That is your single most important piece of intellectual property. It's more important than any copyright you have, more important than any patent. It's your brand name. It's the name Angry Birds. For example, Final Fantasy. So you see this logo behind Final Fantasy. That logo is also trademarked. So the most important things, there's the title of your game, there's the logo of your game, there's any tagline that your game may have. There's also your company name, your company logo, and your company tagline. So for that, think of Nintendo. Nintendo is not a video game, but it's a brand. It's a very well-known brand, and the word Nintendo is trademarked. And they also have a logo, and they have a tagline. For example, now you're playing with power, or get in or get out. Those are all taglines, and those are trademarked as well. Another really easy, probably one of the easiest examples of trademarks of 3 different types are, and well-known, is Nike. The word Nike is trademarked for athletic apparel. The swoosh is their logo. And Just Do It is their tagline. And you cannot sell athletic apparel and say Just Do It, because that's trademark infringement. Now here we have R and TM. Most people look at these, they know it has something to do with trademarks, but they don't really know exactly what it means. And I'm always very excited when I meet a developer that are using R and TM correctly, because that tells me they've done their homework and they know at least a bare minimum about intellectual property. So the R means it's a registered trademark. That's it. So R stands for registered. And TM means it's a trademark, but it's unregistered. That's all. It's very simple. But you can put TM on your game title and your products. If you have not registered the trademark, once the registration goes through, you change it to R. And the R simply serves an important function of notice to people that you have a registered trademark. So now we're going to talk about copyrights, just a brief overview of copyrights. So again, this is Final Fantasy. Copyright protects unique expressions of creativity. Unique expressions of creativity such as source code. When you write source code that's copyrighted, all of your game assets, your art, your sprite, your textures, your characters, that's copyrighted. The audio, the music, the sound effects, that's copyrighted. And most importantly, honestly for video games, is the final audiovisual presentation of your work as a whole. Just the audiovisual effect that your game has on the consumer, just looking at it as a whole, that is copyrighted. And that's very important for enforcing against clones. Because if a clone comes too close to your game, audiovisually as a whole, it can be considered copyright infringement. So that's just a very brief overview of copyrights, trademarks, why IP matters to you. And now we're going to get into the meat and bones of this presentation, the 4 common mistakes that video game companies make. So mistake number 1 is thinking that an NDA is all you need with an independent contractor. A lot of especially smaller, medium-sized video game companies make this mistake. They have these independent contractor agreements, and it sets up how much money they pay the independent contractor by the hour, and there's a lot of confidentiality clauses. And there's nothing in there that's called a work-for-hire agreement. And this can honestly be a catastrophic mistake, because if you hire an independent contractor and there's not a work-for-hire clause in your independent contractor agreement, they own the copyrights to everything they create for you. That means if they create your source code, your game assets, literally everything in your company, they own everything they create. They own the underlying copyrights to it. And this surprises a lot of companies. They think, well, if there's an NDA and I pay them and I kind of guide them on what to make, shouldn't I own it? And the answer is no. It has to be explicit in writing saying that you own the copyrights, the company does, or they do. And this can be a huge problem, obviously, because if they own the underlying rights, they may be able to sue you if you try to make a sequel to your game. They own the rights, and they're simply licensing it to you. When you paid them by the hour, you're paying for a license to what they're making. Maybe if a large company is trying to invest in your company or purchase your company, their lawyers doing due diligence will find out that there's this huge intellectual property problem. It could hold up the deal. It could end up making your company worth a little bit less. You may have to pay off this independent contractor. If he gets a good lawyer, he'll ask for a lot of money, and that will come out of your pocket, and that's not what you want to happen. So here is what a work-for-hire agreement looks like. It's very simple. It's 1 or 2 sentences generally, and you want to go through and make sure that this sentence is in every single independent contractor that works for you currently or has ever worked for you in the past has signed a document that has this clause in it. Here's what it says. Contractor acknowledges and agrees that all of contractor's works shall be considered a work made for hire, and that company, that's you, obtains ownership of all the rights comprised in the copyright of the work. It's very simple, but it's actually very surprising how often companies just don't have this. So it's just something you want to be aware of, flag, check to make sure. Mistake number 2 is weak intellectual property assignment agreements with your employees. And before we were talking about independent contractors, this is often a clause found in your employee agreement with your employees. This is often a mistake where the independent contractor agreement, the work for hire, every large company, mostly well-established large companies will have that in place. They will still screw up. Even the Blizzards, even the huge companies, will often screw up their IP assignment agreements. And there's many holes, there's many ways to have these screwed up. Essentially what they say is that any intellectual property that your employee makes while they're working for your company belongs to you, especially if it's within the scope of their employment. You know, if they're using your company resources and you've hired them to make video games and they're using your company resources to make video games, or your company's code to make the video game, that needs to belong to you, or you need to have a first right to it. So for example, here are I'm just going to point out a couple of mistakes that I've seen large companies make that's come out to haunt them later. And the first one is an IP assignment agreement assigning nothing but inventions and trade secrets. It says employees shall assign all inventions and trade secrets to the company. Well, what's the problem with this? The problem is that inventions are patents and trade secrets are trade secrets. Neither is a copyright or a trademark, right? So this company had a lot of trouble establishing ownership of its copyrights and trademarks that its employees had created, and it caused lots of issues, and it's a story for another day. I'd be happy to explain it to anyone after the talk. Here is a second mistake I saw very recently. Their employee IP assignment agreement was a little broader. It said any and all intellectual property, and it said employee assigns and conveys any and all right, title, and interest in any intellectual property of the company. They thought this was very broad, and I'm sure most people would think this was good, but there was one very slight, minute error. Did not have the word hereby in it. And what happened was, and you know, maybe the attorney that wrote their agreement wasn't really an IP specialist. The word hereby to him, he thought it was just extra. You know, what could that possibly mean? It looks excessive. Strike it. Well, here's what happened. This last year, a plaintiff, let's call them just a software company, medium-sized software company, sued another medium-sized software company, let's call them defendant, for stealing their intellectual property, the ingenuity at the core of their business. And it turns out the defendant probably did steal it. And they probably should pay for it. And they probably should have gotten in trouble for it. The plaintiff probably should have been compensated. Or the plaintiff should have been able to make the defendant stop using it. But that's not what happened. The defendant's savvy attorney read the IP assignment agreements, saw that it didn't say the word hereby, and got the entire case dismissed because there's no standing. Because without the word hereby, the court said it's simply a promise to assign the intellectual property. So without the word hereby, it's simply a promise to assign the intellectual property, and you need the word hereby to actually at that moment assign it. So this is simply a contract, and you would need a separate assignment agreement to actually assign the intellectual property. So the plaintiff was suing over intellectual property they did not own, which meant they had no standing, which meant case was dismissed. And the interesting follow-up to that was that the employees, this intellectual property had been created by the employees a few years earlier. Some of those employees were now ex-employees. So they had to go back and try to get those employees to assign the intellectual property, which is totally possible. You can work with a lawyer, get them to assign an IP assignment agreement. But some of those guys were now working for their competitors. So you're going to go to your competitor's employee and say, hey, you own our company's intellectual property, sign this agreement. But now it seemed like the competitor, because they'd signed IP assignment agreements, now with their new companies, maybe their competitors own their copyrights and their intellectual property. It was a mess. It was a huge, huge mess. And what this goes to say is not that you don't need to go back to your employee agreements and see if the word hereby is in there or see if it assigns all intellectual property. That's not the point of this. The point of this is that there's simply a lot of mistakes to make. This is a minefield, and the last thing you want to do is download a form from online, use a template that's 5 or 10 years old that's not updated, or honestly use attorneys that aren't intellectual property attorneys. Because some people don't realize that attorneys, we're not generalists, we're not specialists like on television. We are specialists. We're not generalists like on television. We don't just know everything. If you came to me with a wills question, I would have no idea how to write your will, unfortunately. We're more like doctors, right? And if you needed brain surgery, neurosurgery, you would go to a neurosurgeon. You wouldn't go to the doctor, the general practitioner, you go for a checkup every year that generally runs your test. You would go to a brain surgeon. If you needed heart surgery, you go to a brain surgeon. And if you trusted your brain surgery to a heart surgeon or a general practitioner, they may get 90 or 95% of it correct. They may have a very good idea of generally how to do it, but they're not going to get it 100% correct. And with things like intellectual property and with brain surgery, you need it to be 100% correct because one tiny word hereby means that you lose, right? So it has to be 100% correct. So you just have to take it very seriously. Okay, mistake number 3, not registering your copyright. So there's this myth in the game industry, and in fact, this goes beyond the game industry. This is almost in all software and creativity. So here's a fact. You do have a copyright the second you create something. The second you put pen to paper and write source code, the second you draw some art, you make some music, you actually own the copyright. You don't need to register it, right? And a lot of people have taken that idea, that concept, and run with it and said, well, if you get it immediately, there's really no need to register it. You don't have to register it. And even other attorneys will tell you this, that no, you don't really have to register your copyright. You have your copyright. If you ever need to enforce it, if you need it, go register it then, and then you can enforce it. Very common. That's a grievous error. The fact is that you have 3 months to file your copyright registration once you've published your work. And if you do not register the copyright in your video game within 3 months of publishing it, you are severely prejudicing your rights. And the registration fee is $55. That's it. And it's $55 registration fee. If you hire an attorney to do it, maybe an hour of their time. And so there's really no excuse not to do it. There's no excuse not to do it. If you don't do it, you are significantly prejudicing your rights. I generally recommend people do it right before they publish or literally the next day. You don't always want to wait 3 months because there are other slight issues where if you wait the entire 3 months, someone that started infringing it, maybe the next week, they could have some rights. So anyway, you do want to register within 3 months, but generally as fast as possible. Mistake number 4. This is one of the final mistakes we're going to talk about. This is not registering your trademark immediately. So with copyrights, you can register within 90 days. You can register your video game copyright within 90 days. And when you register that copyright, that $55, that goes to the entire audiovisual presentation and the source code. It's literally one fee One application is very quick, and it goes to your entire video game, the source code, the art, the sound, as long as you created the sound and you're not using Creative Commons. Again, you have 3 months. For trademarks are different. You need one trademark for your game name, a second trademark for your logo, a third trademark for your company game, a fourth trademark for your slogan. If funds are tight, just trademark your game name. That is a must. You must trademark your game name, and there's significant problems of not doing so. And unlike copyrights, where we can wait 3 months after publishing, you want to register the trademark of your game name literally the day you decide, or the day you think of that game name. So here's an example, Podium Man. I'm up here on the podium, let's make a video game about this. So if we decide, a year before release, we're gonna name something Podium Man. And again, we're a year from release. You should go to the USPTO and register that trademark for video games immediately. In fact, you can register trademarks up to about 3.5 years before you actually start using it and selling the video game. And the reason you want to do that is because your trademark establishes your presumptive exclusive right to use that game title for that video game. And there's a lot of reasons why that's important. The most important of which is you do not want other people to stop you from using it after you've already released your game. And this is something I've seen often and is a huge problem. So you have Podium Man, and you spend the next year on marketing, SEO, you buy a domain name, you actually build up a community, everything's going swimmingly, you release your game, you get press, people love it, you start building traction, but it turns out then you receive a cease and desist letter. Or your game just simply gets pulled from the App Store, or from Steam, or from wherever it is online. It turns out that a week before you released your game, someone else had the idea for Podium Man, and he registered for video games. And you hadn't really started using your mark yet in interstate commerce, so and you hadn't registered it yet, so you don't yet have any presumptive rights. But he registered it, even if he's not using it. So he is first. You can't beat him on first use. You can't beat him on first to file. So he simply you are, for lack of a better word, screwed. He will have your games taken down from Apple, iOS. You'll have to change the name, rebrand, re-upload it, start over. It's a disaster, right? You may have to buy a new domain name, restart your SEO, do all the work it takes to change the name, then wait a week for Apple to re-upload it, and then no one knows it's the same game. It is a huge problem I've seen. Sometimes you can just pay off these people. Sometimes you can't. You just don't want to be in that position of not being able to use your game name. So trademarking your game name the second you have the idea is extraordinarily important. It's far more important than your logo. It's far more important than your company name or anything else. Okay, and on that note, I'm also going to say that there is another myth out there that's not on my slides, but I've heard it just from talking to people this week at the conference. And they say that for video games, there's really no way to protect your intellectual property. If people clone your game, that's completely illegal. And there's really no copyrights for video games, and intellectual property is just not something you can protect. That's a myth. You can absolutely remove clones from everywhere. I've had literally I've gotten thousands of clones removed from online. Amazon, iOS Store, Apple, Microsoft, Facebook, everywhere online, websites. If the website is hosted in other countries, even in China and Russia, sometimes you can still have them taken down by going straight to the ISP and notifying them of the intellectual property infringements. In every country, they're getting very good, especially the ISPs, about enforcing intellectual property rights, especially registered intellectual property rights, which is generally the first question they ask. So it really is possible to protect your intellectual property. And if you haven't registered your copyrights, registered your trademarks, if you don't have the right agreements in place, and if you haven't protected your brand, you will never have the opportunity, your video game and brand will never have the opportunity to become the next Angry Birds, right? It just won't be there, because to be the next Angry Birds, there has to be a lot of power and a lot of power behind the brand name. You have to protect it, you can license it, you can merchandise it, but unless you've taken all 4 of these steps, you're just not going to be able to do that. But let's say you've taken these 4 steps. Let's say, and these are just the most common mistakes that people make. There's more, but those are the most common. you have your work for hire agreements with your independent contractors. You have solid IP assignment agreements with your employees. You've registered your copyrights within 3 months of publication, and you've registered your trademarks the second you had the game name. Great. You're going to be able to defend yourself from lawsuits, right? People are much, much less likely going to sue you. You're going to be able to grow the value of your brand in your company, whether it's from people acquiring it, whether it's from licensing deals and merchandising, whether it's from just getting investments from venture capitalists. You're going to be able to grow the value of your company. And finally, you're going to be able to enforce your brand, enforce your copyrights or trademarks against shameless cloners. When people clone your game and try to take a piece of your pie, try to take some of your market share, and essentially just steal your ingenuities, because we all know there's dozens of companies, or if not more, just in their entire thing is just to clone. And you can stop them. And you can only do that, though, if you follow these steps. And that's all I have for now, but that was a very brief overview. But I'd love to answer questions and talk with you guys more about this if we have time.
Thank you, Stephen. I hereby say that was an amazing talk. And my question is, how does a lawyer do such good-looking slides? Your slides are so good-looking. Casual Connect has hereby decided that they will be on every conference badge. So, well done. Anybody have a question? Please keep your hands in the air, all of you, so that we know where the mic goes next.
Hi, very interesting lecture. Quick question regarding Angry Birds versus Candy Crush, for example. Both hugely successful. There's an immense cloning of Candy Crush and Jelly Beans all over, and I don't get it, because they're equally as big as Angry Birds. And second question is, are you not allowed by law basically to make a slingshot bird game? Because why aren't there many other different clones just, not getting close enough, but clone the game anyway? You don't see a lot of cloning bird games out there, but you see Candy Crush cloned everywhere.
Okay, so so I'm going to talk about Candy Crush first. So Candy Crush is an interesting take because some of you may know about a year and a half ago, they were actually trying to enforce their copyrights. They were sending lots of takedown notices to games, and basically they were trying to take down everyone that was copying them. But they did it in a very poor way for several reasons. So first off, the video game community as a whole is extremely sensitive towards people over-enforcing their intellectual property rights. And the last thing you want to do is send a cease and desist letter to someone, have them post it to Reddit or Twitter, and all of a sudden you have 1 million people retweeting and upvoting on Reddit saying they'll never buy your game again and creating bad publicity. And they crossed the line and they went there. A few of the mistakes they made. So they were trying to enforce the Candy trademark. So they were trying to take down any game named Candy, even if it wasn't a match 3 game, right? So it would be like someone it'd be like if Rovio was trying to take down a game called, like Angry Militia, an FPS game, just because it had the word angry in it. It didn't make any sense. They were over-enforcing. The other interesting thing is they actually didn't have a trademark for the word candy. They were trying to enforce a trademark they never owned in the first place. And they were also trying to enforce the word saga for their company name against a Viking game where saga is actually descriptive and means some kind of epic quest for Vikings, right? They were actually using it in the descriptive sense, not in the branding sense. And the game it was not a match 3 game. It was an RPG. It was some kind of real-time strategy RPG, some great game actually. And so these weren't clones. So they were trying to enforce it against games that weren't clones. They got a lot of backlash. They ended up having to basically withdraw lots of objections to people trying to register their own Candy trademarks. They were also trying to enforce Candy against games that came first, right? So someone had Candy in the App Store. 2 years later, Candy Crush comes out. Candy Crush sends them cease and desist letters anyway. Those are all big no-nos. You shouldn't do that. Created lots of bad publicity. Essentially, Candy Crush wasn't very successful. They didn't copyright their game within 90 days. They didn't get a trademark they didn't quick enough get trademarks for Candy because other people had gotten there first. They may have been able to trademark Candy Crush without claiming ownership over Candy and take down other people literally named Candy Crush, and they may have done that already. I'm not sure. And the other thing is they really didn't invent the match 3 genre at all, and their games look way too close to everything that came before to kind of say, if someone's games look a lot like Candy Crush, they can say, well, my game does look like yours, but it also looks like this other person's that came before you, and it's really we both just took it from them. So I didn't copy you, right? I copied them. And that's actually a defense because, Candy Crush can't sue you for someone else's intellectual property rights. It's kind of like what's going on right now with Blizzard, how Blizzard sued. I don't know if people have seen this lawsuit. Blizzard has sued this. And it's actually a defense. For the original guys that were sued, it's a defense to say, hey, we may have copied you, but you copied Warcraft, so you don't own the intellectual property, right? There's no standing to sue here. But it may backfire because I think Blizzard is now going after everyone.
Thank you very, very much. That was an excellent talk. Let's all give him another round of applause, people.
Thank you.